Welcome to the Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, we've created this program to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We continue to provide the resources and information to help you decide whether or not you actually need to work with a lawyer. We'll help you at times decide that you might be able to handle some issues yourself. If you do decide to contact professional counsel, you'll be better prepared, and hopefully so will the professional you select. Our goal, of course, is to help you achieve the best possible results as you save time and energy and hopefully money. We continue to thank and welcome David Bazar, the Bazar and Associates law firm in East Providence, who help us with all of the issues that we tackle. And today, our topic is automobile accidents. The personal and financial costs are staggering. We're going to do a little bit of the anatomy of an automobile accident claim, what you need to know, how to plan for it, what the process is about, including that settlement process. What are those settlement issues that deal with damage and injury and pain and suffering? Truly, the costs are staggering, and just taking a quick overview, a quick look under the personal injury banner of car accidents, the cost of car accidents in the U.S., and this isn't the most recent statistic, it said alone car accidents, highway accidents, $871 billion a year in economic damages, and they say $594 billion is the cost of the social harm from highway accidents. Not surprisingly, they include the speeding, drunk driving, distracted driving, all of those kinds of things contribute to some of the biggest economic impact these days, or are new factors. So of course this triggers the discussion about negligence and personal injury, and of course David is very well equipped to handle this. So let's address what happens with a car accident. I understand Rhode Island has a mandated car insurance. Massachusetts has its own required coverage with some limits. So you have an accident, insurance covers it. Obviously, that is not the story. What do we need to know? Well,
that's the beginning of the story.
Yes.
It's not where the story ends. Although that actually raises some interesting issues in and of itself. So we'll start with the insurance before we get to the accident. As you said, Rhode Island has compulsory insurance. Everyone's mandated to have insurance coverage in a minimal amount of $25,000 per accident, $50,000 per person, $50,000 per accident. So in other words, if there are 4 people in the accident, your liability coverage will go up to $50,000 for the one accident. The most any one person could get on the minimum is $25,000. That's liability insurance. It's a requirement so that if you injure someone, there's protection for that person. In addition to that type of insurance, there's uninsured or underinsured motorist coverage that you can have. And it's required in Rhode Island that each person have an amount that is equal, or that it's at least offered to them, equal to the amount of their liability insurance. So if you only got the minimum in liability, you would be able to get at least $25,000, $50,000 in uninsured or underinsured motorist coverage. So what that protection provides you is, if you are injured by a driver who doesn't have the required insurance, you'll at least have coverage from your own policy to provide what they should have provided. Or in the alternative, if you're injured by somebody who had coverage, but it's not enough coverage to protect you against the damages that you incurred, then you can go to your policy for the difference.
May I interrupt you just for a moment? About that uninsured motorist or underinsured motorist, I read somewhere, help us with this, that in Rhode Island at least, you have the right to reject that element as long as you put it in writing. And what does that do? Well, how does that impact on the story?
So that is correct. When you get your policy, if you don't want to pay for that coverage, you can reject it. It doesn't save you very much money. It's not a very intelligent thing to do. It's coverage that, even though we have theoretically mandatory insurance requirements, a lot of people don't have insurance, and you need to protect yourself. And of course, you hope you never need to use it at all, but if you do, and the other driver has insurance, but it's not enough to cover your damages. And in Rhode Island, this is much different than Massachusetts, and we'll talk about that in a minute. If your damages are $60,000 and the person has $25,000 in coverage. If you don't have the underinsured motorist coverage, that's all you're going to recover. Whereas if you have the coverage in Rhode Island, it's tacked onto whatever you already recovered. So if your claim is $60,000 and you have another $25,000 in coverage, you're going to get that extra $25,000. So you'll get $50,000 at least in that claim. And if you have more underinsured or uninsured coverage, you'll be able to claim more up to the amount of your damages. In Massachusetts, it's 20/40, which is what is the minimum that you can have for liability insurance. And you can get uninsured, underinsured 20/40 as well, but it's different in Massachusetts. And the reason you need to have more underinsured coverage in Mass than the minimum tells you can get is because if I get into an accident in Massachusetts and I have a Massachusetts policy and I live in Massachusetts, if the driver who injured me had $20,000 worth of coverage and my damages are $60,000 and I have 20/40 underinsured or uninsured coverage, I don't get any more money because the set-off is not against my damages, it's against the amount of insurance the other driver had. So if the other driver had 20 and all I have is a 20 UM policy, I don't recover anything, even though my damages are more.
So if that's the scenario, is that what gives rise to better contact a lawyer? Because who knows that the insurance company, when the adjuster comes in, he might even say it's not even worth the 20. I'm not saying that that happens, but it could. All right, but let's, for the sake of argument, suppose they did say that you get the full 20, and as you're saying, but there were other circumstances. That person shouldn't have rear-ended me or whatever. Is that why we need to contact a lawyer before we sign on the dotted line with the insurance company?
No, that's not really the reason. The reason you need to hire a lawyer is because two things. Number one, how do you value a case and what goes into the evaluation, and is the insurance company fairly compensating you for your damages? Number two, what other coverages are there if there's not enough coverage and you need to be able to know insurance law and go through those policies and know what you're entitled to? Are you entitled to PIP coverage in Massachusetts? Is that an offset? PIP is personal injury protection. Is that an offset against what's being paid by the insurance company, or does that have to get paid back? In Rhode Island, medical payments or med pay is a policy coverage, and that can cover your medical bills, and does that get paid back or doesn't it get paid back, and who's responsible for that? So there are a lot of things that go into it that you should hire an attorney for, and most attorneys take it on a contingency, so you're not paying them out of pocket.
And as you're continuing to set this up, which is what we wanted to explore today anyway, there is that element of what about the negligence, and sometimes that's the story. So can you go over briefly what that negligent component is about?
So we can get into that. I just want to finish one more thing with insurance.
Fair enough.
In Massachusetts, you also have to be careful about one other thing.
Which is?
Some policies in Massachusetts insure you for accidents for liability in Massachusetts only. So if you live in Seekonk and you drive to East Providence and you go over the line and you hit someone in East Providence and you have this particular type of coverage that says Massachusetts only, you are not covered. You have no liability insurance that covers you and protects you in Rhode Island. So make sure you don't get that policy.
That's an interesting issue.
In Rhode Island, I believe, made a mistake in the Supreme Court on that issue, because I said that they should require the insurance company to provide coverage because insurance is mandatory in Rhode Island. And so if, I'll make up a name, MetLife writes a policy in Massachusetts for 20/40, when you drive into Rhode Island, which has a 25/50 requirement, and you get into an accident, by law in Rhode Island, we step that policy up to 25/50 because we say you have to write a policy that meets the minimum of what we require in Rhode Island. And the courts have said that that's fair. You rewrite a contract to provide what's required. Well, insurance is required, but the court didn't say that the Massachusetts Metropolitan Insurance Company, even though they write business in Rhode Island, should be required to provide coverage to its insured in Rhode Island if you didn't buy a policy that provides that. I think it's the wrong decision based on what we do with the minimums and how we step it up, but that's what the court said in that case. So if I live in Massachusetts, I want to make sure I'm covered wherever I drive. Now I can go to the anatomy of an automobile accident if you'd like.
Okay,
So the first issue you raised is the liability. And oftentimes liability can be contested for a multiple number of reasons. For example, we have an intersection and it's controlled by a light, and both drivers go through the light, and both drivers claim they had the green light, and who had the green light, and what can we do to prove who had the green light. So that's an evidentiary issue that a lawyer would want to get on as quickly as they can. Try to find witnesses, the cameras. Many of these intersections now have cameras in them. Can we get the images from the cameras to show what might or might not have been going on? Other types of cases, a case with, I had once with Ripta, which is the bus company in Rhode Island, and their driver pulled out of a side street, cut my motorcyclist off, forcing him to lay the bike down, and the bus just kept going. And it's my understanding that maybe bus drivers are instructed, if you didn't touch somebody, keep going. But luckily we had other witnesses there. We found them immediately. I took statements from them, and we were able to track down exactly what bus it was and prove that the bus was there at the time, because they have GPSs on the bus and we can track these things, and we're able to prove that the bus was there, the bus did cause the accident, and we had a claim. Whereas if we didn't do that, we either may not have had a claim, or it would have been an uninsured motorist claim, which brings up a whole nother bunch of issues. So liability out of the gate is the first issue you need to deal with.
We've often talked about how important it is to have evidence, whether it's a photograph or whatever. But and I think we need to talk about the statute of limitations. I know that there are some, and we need to be aware of that. But if that person who was on the bike didn't think to call you or call someone for a month, 2 months, 3 months, how is it possible that you could have ever reclaimed that the people who were there as witnesses?
Right.
Wouldn't that have been gone and evidence lost? Maybe you'd still have the footage, but...
It potentially could have been gone because the witness was kind enough to give his name and number, but what if he either moved and had a different number, or the telephone no longer works, so the quicker you get there, the more likely it is it's going to work?
Clearly.
What if it was too far down the road and he had a memory, but it wasn't as clear as it was a week or 2 weeks later, when we actually were able to contact him, and he was able to write out with a lot of specificity exactly what happened, what he saw,
Yes.
what people look like, how many people may or may not have been on a particular bus at the time, where the bus came from, all of the important issues that we needed to have in order to prove that this actually happened the way my client said it happened, and then the way the witness backed him up on it.
And so the issues about negligence, the stuff of which personal injury in many cases may, go over that a little bit when it comes to car accidents, if you could.
Okay, so we start out a negligence claim with the liability, as we were talking about it.
Yes.
The negligence is that I have a duty to someone, I breach that duty. As a result of the duty, there's a causation, which is that I've injured somebody, and then what are the damages? So A, B, C, D, a duty, breach of the duty, causation, damages.
Thank you. I think I'll remember that
Yeah.
more easily next
Right.
time. How about comparative or relative fault?
Okay, so I think what you're talking about now is comparative negligence, or damages that are, so in Rhode Island we have what's called pure comparative negligence, which means that you may have been responsible for the accident, I may have been responsible for the accident. So we take a look at what the degrees of each of our contribution, so to speak, to that accident is, we then adjust it against the damages. So if it's a green light for both of us, or at least we think so, and we can't prove otherwise, and it's 50-50, and I damaged you, you would get 50% of your damages back. If you were 60% at fault for the accident, you'd only get 40% of your damages back. In Rhode Island, that's pure comparative, and we just base it exactly on what liability is found to be placed on each of us. In Massachusetts, contributory negligence, you have to be 50% or less responsible for the accident. So if you're 50% or more responsible for the accident, you may not receive anything. If you're 60% at fault of the accident, since you caused the accident to a greater degree than I did, under Mass law, you can't recover anything.
So we say we're trying to equip people to perhaps handle some issues yourself. If both are insured motorists, they both have insurance, you might be able to say, then you shouldn't need to enlist a lawyer. And at what point does the average victim of a car accident have understanding of the calculation of what 40% of this is and 60% of that? How does that enable someone to handle such an issue themselves?
They can't. So the survivor rather than the victim.
Yes,
of the
okay,
accident.
that's what I meant.
Okay.
Good point of
Yeah,
clarification.
should contact the attorney immediately, because it's not just the liability that needs to be looked at, it's the damages. So a lot of people try to tough things out and take care of things themselves, and I will tell you that you can be very injured in an accident, and for the most part, even if it's a soft tissue injury, you think, well, I'll stretch, I'll work it out myself. Without any medical documentation of your injury, insurance companies are very unlikely to pay very much at all for that injury, because if it wasn't significant enough for you to require treatment for it, it's not significant enough for them to pay for it. And it's not usual for an insurance company to say, oh yeah, you were really hurt, your neck hurt you for 3 months and you didn't do anything about it, we'll pay you anyway. Not likely to happen. So that's one of the things that an attorney can speak to you about. And I would never tell anybody to do anything other than what is best for them in terms of their own health and treatment. I don't recommend, go here, you do this. I would tell, if someone asked me, I might say, well, this is a person I know who's got experience in a certain area of medicine or whatever. If it's a broken leg, you want to go to an orthopedic doctor. But I always tell people, go see your doctor, your primary care physician, if you will, and tell them what's bothering you and let them direct you to where you need to be for the best care that you can get. And if you think that you can benefit from some physical therapy, have your doctors, talk to them, and they agree, they'll send you there. But it's documentation that's very important, that it's just like all other evidence. You have to have documentation and evidence of the injury. The best way to document damages for pain and suffering is to document what it is that you're going through medically.
So we haven't spoken much about the pain and injury and pain and suffering and the rest, but we see that those payouts for car accidents have been very hefty. I don't know, I know what cars cost. I think that there are actuarial studies that say if you broke your arm, here's what it's worth. But as I was looking at these listings of the elements that you have to consider, loss of productivity, quantifying this must be interesting, car repairs or replacement, that would seem fairly easy. Environmental costs like cleanup if there's whatever happens on the highway or whatever. Lost wages, lost earning power, lower standard of life, hospital costs, lost household income, legal costs, insurance costs. I understand insurance costs go up, but these things must be interesting and difficult to quantify. So what's the anatomy of a case to have this end up equaling some of these sums that are in the millions?
So the big payouts that you're talking about include a lot of these cases could be property damage only cases, and it's the cost of repairing the vehicles and all of that. That's a big component of the payouts. The payouts aren't astronomical, they're not huge, and it's all based upon what the case is. The average case where there's some personal injury, and it's usually a soft tissue injury, are not astronomical payouts. But what goes into them is the same thing that goes into a case where you're looking at catastrophic injury and a much bigger payout. So for example, if somebody is in an accident and they had a job and they can no longer do their job or can't do it for a period of time, how do you document it? Well, one of the things you do is you get a statement from your employer, the attorney would do this, to lay out what your lost wages are. That's a component of your damages. So I had a job making $500 a week, and I couldn't do it for 5 weeks. We get a letter from your employer, maybe with a breakdown of your 13 or 26 weeks prior to the accident to show this is what you were making, and a note from the doctor to say that you couldn't work that time. So it all lines up that you were out of work because of the injury from the car accident. Medical professional says, nope, can't do that job, too heavy, it's going to prolong your injury, and therefore you can't do that job. And then the employer documenting what it is you made and how much it is you lost. That's one component. That component would also document what we would call total pain and suffering versus partial, where you really can't do much of anything because of the injury. That's worth a greater amount of money for that period of time than if you're partially disabled, where I can still do my job, it's a lighter duty job, I'm able to do other things, but I really still have this pain. They're going to pay you at a lower rate for that, the insurance companies. And when you go in front of a jury, if you had to, the jury would compensate you a little bit less for that as well.
And you aren't a good housewife anymore, or you aren't a good husband anymore in various things, from sliding into second base to whatever other issues that can be impacted on a marriage. There are calculations for these things, David?
Yeah, so you're talking loss of consortium or loss of companionship, that type of thing. There are. And again, it's the spouse's claim for the loss of society, companionship, or other things that you might not have in a relationship. In a lower damage type of case, what I mean by that is the personal injury might be a result of neck, back, soft tissue injury. There could be some component of that, as opposed to a case where now we've had these situations where someone is quadriplegic as a result of the accident, and it's a much more serious claim both for that person and the spouse, because now the spouse has not only lost the companion in society in relationship with that spouse, but is now providing perhaps services to that spouse that no spouse should have to provide to another spouse. And the life and the relationship is totally changed and different, and there's compensation that really needs to be paid not only to the injured spouse, which would be significant, but to the other spouse who's been damaged as a result of the negligence of the tortfeasor.
So I arbitrarily picked up some numbers. I think it might have been in Tennessee. $20 million for a truck accident where a tractor trailer ran a red light, hit a car, leaving the man with permanent brain damage along with other injuries. $4.25 million, someone in a truck ended up running an intersection, caused a death. $2.7 million, a rear end collision. Are these things, okay, I did just arbitrarily select these. Are these things unheard of, or does that sound reasonable, feasible?
Here's the thing. Now, we're looking at 3 cases you just rambled off there. And you're telling us what they got, but I will tell you what went into the damages to get to those numbers.
Okay.
So we have a man, and I don't know anything about these cases, so
right.
It's hypothetical.
Exactly.
Traumatic brain injury from an automobile accident. So this fellow had a job. He was making $100,000 a year. He was 40 years old. He's not going to be able to work anymore, so he has all of those lost earnings for the rest of his work life expectancy. That goes into the formula. Beyond that, now he needs 24-hour-a-day care for someone to come in and take care of him. He needs all sorts of other medical devices and medicines and all of these other things. So we hire somebody who can do what's called a life care plan to tell us how much it's going to take care of this man, I think you said he was a man, for the rest of his life, and that goes into the formula. That's going to be a really big component to what this is, because not only do you have to take in what it costs today and figure it out, and it might be $200,000, $300,000, $400,000 a year to take care of him, to keep him out of a facility in his house with his family and all of those things, but it's for the rest of his life, and medical expenses go up at a much higher rate than the rate of inflation, so you have to factor out how much money it's going to require over his life expectancy. So now you plug that into the formula, and $20 million might not seem like a lot of money.
And he has children and their college education, or what about he's young and hasn't really even peaked in his career yet? Who knows, whatever else he could, what's this future loss?
It's all part of that pain and suffering component, which I didn't even get into. I was just talking really about the economic damages,
yes.
But add in the pain and suffering and the loss of the life that he would have had, and the children no longer have a father who they know or can really relate to because he's got traumatic brain injury and he's a different person. The wife doesn't have a spouse anymore. That number might be low.
Interesting. So when an accident happens, obviously the first thing that has to happen is the person's in the hospital. Say they can speak, they can't speak, someone needs to reach out to, never mind the insurance company and the person's employer, but also to a lawyer. speak to the statute of limitations. Obviously, it doesn't mean 24 hours, but there are reasonable limits.
Yep.
So would you address those?
For a personal injury case, Rhode Island and Massachusetts, generally speaking, you have a 3-year statute of limitations, which means that you either have to settle the claim or put it in suit before the expiration of the statute or the 3 years. There are some exceptions to those, and what I would suggest is that you speak directly to an attorney, but if you live by that 3-year SOL, statute of limitation, you'll probably be somewhat safe. I always tell my clients I don't wait till the last day. If we know it's not going to settle because you're either still treating and you need to treat, we put it into suit sooner. But that's a hard and fast rule. If you haven't filed within the statute of limitations and there's no exception to it, and there are very few, then you're going to be barred from filing.
When someone speaks to you, it may seem like there's going to be a settlement, but there isn't. You think there might be a lawsuit. Do you proceed with a lawsuit and then continue discussions towards settlement?
Yeah, you always do that. Just because you feel you have to file a lawsuit doesn't mean settlement negotiations have to stop. You continue to talk. And if you can't settle it through negotiations, you do have all of the alternative dispute resolution models we've talked about many times in the past between arbitration or mediation or settlement conferences with a judge, any type of thing like that might lead to a settlement before a trial.
So in the brief amount of time that we have left, tell our viewers what kinds of things in terms of documentation, you always say document, what kinds of things can they do even before they pick up the phone or actually meet with you? What kinds of things can they do?
Police report.
Okay.
If you bring in a copy of the police report, that's a very helpful tool to tell us everyone who was involved in the accident, how the police at least see the accident as having unfolded. That is not conclusive as to what happened, but it's usually a good start. Insurance policies, if you have those available to you, bring those in. They can be very helpful. And any medical records that you may have already had from an emergency room visit or something of that nature.
Okay, and when it comes to thinking about settling, do people need to be very concerned about what they are restoring for wages versus personal injury and what it's actually going to cost them minus your fees if you settle?
Well, what we do is we take all of that into consideration, and we look at the pain and suffering, the lost wages, the medical bills, other expenses that you may have incurred. If there's a claim for loss of companionship or society, a loss of consortium claim for the spouse, we bring all of that in, and we figure it all out. Then when we get to the end of the day, after all the bills have to be paid back and the lawyer's paid, it's really how much will I end up with in my pocket. So I always tell my client, it's a two-way street. We work together. I'll tell you what I think, you tell me what you think, and we'll come to the right answer.
And you usually bring in an accountant too, as I recall.
If it's necessary in certain cases, an economist.
An economist, okay. I know at times we've spoken about the structured settlement. We may do that later. We thank you for tuning in to The Law Matters, and we hope that you never have to deal with this, but stay tuned to The Law Matters. It matters to you.